Hopefully everyone can hear me. I'm Eric Boughman. Happy to be joined by Gary to my right, your left on the screen, and then Brian is joining us remotely. Hope everybody's doing well during COVID time. We've got a lot of material, and we have a seminar that for some reason we thought we were doing this for about 2 hours, which is a long time for us to talk. And we have a material that could probably go for 3 or 4 hours. So by all means, if you have questions along the way and you throw them up in the chat, or if you have anything after the fact, please do not hesitate to reach out and contact us. We will probably go a little faster through some of the slides. There's certain points that we want you to capture, and we'll make sure to share this with you. So there's our agenda for today. Again, a lot of material packed in here. We'll talk a little bit of foreign trusts, some tax issues. That's all Gary and Brian. Asset protection issues, cryptocurrencies. This originally started out as just a seminar to give us a way to talk about cryptocurrencies a couple of years ago in a practical sense. Apparently this has gotten to be a thing now, especially during COVID. It seems like people are actually looking at cryptocurrencies as a safe haven. I won't comment whether that's wise or not, but it is what it is. So let's just jump in. And when we start talking about the foreign tax and asset protection issues, I'll turn more of that over to Gary and Brian. There's your piggy bank with the Bitcoin in it.
Is that your bank?
Theoretical? No, because the Bitcoin doesn't actually reside in the piggy bank. It resides in the virtual world, and we'll find out later in the seminar how all the different ways that you can hold Bitcoin, including in your mind. All right, asset protection trusts. The important issue here when you're talking about using trusts for asset protection purposes, especially self-settled trusts, understand that you can't do a self-settled trust in Florida. You can try to create one. People do them apparently and make a trust for themselves, or go to a lawyer who will do that, but it has no asset protection benefit. A revocable trust has no asset protection benefit, and one form for yourself here in Florida does not do anything for asset protection, but there are certain states that do allow them, as well as foreign jurisdictions where you can create a trust for asset protection.
Well, for yourself.
For yourself, that's right.
So in the 80s, what had happened was the English common law doesn't allow you to create a trust for yourself that's protected from your creditors. So that developed for a few hundred years, and in the 80s, a few of the English prior colonies decided that they would like to attract a lot of foreign monies. So they decided to change that, and they created these trusts you can form for yourself and your family that are protected from your creditors. And that created this, what's called the Asset Protection Trust, a self-settled asset protection trust. And we'll walk through some of the jurisdictions abroad that may be better than others. And then we'll walk through the fact that a few years ago, actually not that long ago, Alaska and Delaware said, let's get into that as well. Let's offer a trust that someone could settle for themselves in our state so that we can attract some money to our state. And as you see in B, foreign versus domestic trusts. Well, when would you want an asset protection trust? And then, are you looking to do a foreign trust, or are you looking to do a domestic trust? The reality is that most people in the US really aren't running to do a foreign trust. I mean, you really need a certain set of circumstances where people are comfortable putting money either abroad or in an entity that's abroad with a trustee that's abroad. So mostly we're looking at domestic entities. A lot of this comes into play when we have an asset protection structure, such as a big LLC family structure or the like, and we have a single individual. So when we have husband and wife, most of the time only husband or wife is likely to really suffer any significant outside exposure to litigation. Sometimes husband and wife can be jointly liable for something, some, a fall in a house where they don't have sufficient insurance coverage, or if husband or wife drives the other spouse's car, you can have a lot of liability, some kind of shared medical practice maybe. But when people are married, they can take title by tenancy by the entireties, which is quite protective. But what if they're not married? The LLC on its best day only provides charging order protection. So if you have an LLC and you're sued as an owner of the LLC, someone wants the equity in the LLC, they can lien that LLC. LLCs are subject to lien. That's not in controversy. The only controversy with LLCs is whether or not you're in a jurisdiction where someone can actually grab the equity. So what you do is you place it into tenancy by the entirety so that the plaintiff requires a judgment against both husband and wife to reach or lien the LLC equity. But if you're not married, what are your options? You're still subject to lien. You really have to do a domestic trust. Or if you feel exotic or you have assets offshore, you can do a foreign trust. The domestic does offer more convenience. We can go through the outline here. In other words, it's really Americanized. You can set it up fairly quickly. It's less expensive than a foreign trust. But Eric can elaborate, because we had a case like this. If assets we use Nevada a lot, for instance. If assets are in Florida or assets are in Nevada and the trust is in Nevada, we're still subject to the U.S. Constitution full faith and credit clause. We had a client come in that suffered a judgment that had the Nevada trust. So Nevada did recognize the judgment. So your shot at that point is not throwing out the judgment, is, okay, once Nevada, you record that judgment in Nevada, what protections do you have with respect to your Nevada trust?
Yeah, and what it does when you create the trust, at least in a jurisdiction that recognizes the self-settled trust, one, it's going to be respected by the courts. We have a note down here. There's a couple cases, Huber from Washington and Mortensen from Alaska, give us some examples of what happens when you don't take into the practical realities. And that is, even if using the Huber case, Huber was a guy who set up a trust under Alaska law. He did a self-settled trust, and his assets were all located in Washington, and he used a trustee in Washington, and
a co-trustee.
Yeah, co-trustee, and
an
Alaska trustee, and actually the Alaska trustee that was named in the lawsuit, in this bankruptcy suit that followed, completely rolled over right away and gave up the goods. And so basically, you're looking at a guy who has an Alaska trust, but the trustee, the beneficiaries, and all of the assets were in Washington. And the Washington court, bankruptcy court, pretty easily came to the conclusion that since Washington had a public policy against self-settled trusts, all the stuff was in Washington. The trustee, again, everything I mentioned.
They went bankrupt.
The
black letter of the law kind of goes away there. You lose a lot of the arguments, and the bankruptcy court's going to do what they want. The problem is these cases start to serve as precedent.
Yeah, but I think that a regular state or federal court wouldn't have had a hard time getting to those assets under those facts.
No connection.
Because there's no connection to Alaska. It's all connected to Washington. And so the trust wasn't respected. And it was treated as an alter ego of the individual, and the assets could be taken. You have the same thing here in Florida. If you set up a trust in another jurisdiction, it recognizes self-settled trusts like Delaware or Nevada or another location, and you keep all of the assets here in Florida. And we have a case, there's an LLC case where this happened, and with Barbara that we mentioned later in the slides, you have a very good chance of seeing a local court basically say that trust is just an alter ego and we're going to treat it according to Florida law. The case that Gary was referring to with Nevada, I think if I'm thinking of the correct one, we've had a couple of these. At least if you go to Nevada, you have a trustee in Nevada, and you have assets that are outside the jurisdiction, maybe in Nevada or somewhere else, in that case, what happened is the creditors tried to sue the Nevada trustee. They wanted to bring the Nevada trustee
Nevada.
here. Well, they started here. They filed the suit
oh,
here.
they went there to pull them. To
No
pull
jurisdiction.
Them in. Yeah.
And so you want to pull them into Florida, try and use Florida law. There's no jurisdiction. So we file a motion to dismiss. We represented the trustee from Nevada. Nevada trustees doesn't have any contact with Florida. And so the court recognized that there was no personal jurisdiction over the Nevada trustee. The remedy then is to go to Nevada and pursue your claim there. But now you're in Nevada, and it's Nevada, not Nevada. I used to practice there. So you're in Nevada, and you're now going to be in a jurisdiction that respects the self-settled trust, trying to argue some type of public policy reason not to respect
Which is what you want. You want to be in the court where the jurisdiction of the entity is, because that's the law that they know.
So that's the big issue. If you're going to work with one of these tools, make sure you have all the pieces in the right place.
I keep thinking tomato, like
it's not. It's Nevada. I'm telling you, if you say Nevada in Nevada, they get very upset. They don't like that.
What you skip Mortensen?
Well, Mortensen, I can go back.
Oh, that's the best.
Mortensen was a bankruptcy case. You want to hit Mortensen?
Yeah, Mortensen's the mountain man. So this mountain man created his own, somehow figured out how to create his own Alaska trust, funded the trust. Several years had passed, got a divorce, and had really done it right. He really wasn't that exposed, and he decided, even though he was in good shape and the local Alaska statute on fraudulent transfer so that she could get into the trust had lapsed, he decided to go bankrupt, which opened up the 10-year statute of limitation, and he lost the assets. I don't know. I find that one a little crazy.
That is an example of trying to be too smart for your own good.
Yeah.
And probably he would have done better had he had a lawyer who could have advised him, who knew what they were doing.
Well, I probably would have just done nothing.
If he'd have done nothing, he'd be better off. All right. So then we talk about
the slides with that pen.
That's what I told you. The Microsoft Surface. I don't sell this. The Microsoft Surface, but the thing is great. Yeah, the pen. And if I want to go backwards, I just hold it down. It's amazing. Foreign trusts. The advantage there is you're outside of U.S. jurisdiction. Very, very tough to crack a foreign trust. The way the courts typically try to do it is to pressure the trust settler to give up the goods by putting them in jail under a contempt order. We've seen a few of those cases.
It's very rare.
In South Florida, very rare. And again, that's the best they can do. If you're willing to sit in jail, then you can wait them out. Some people will. One guy in Pennsylvania sat in jail for 9 years, so his wife wouldn't be able to get to his assets. That's the longest. Lawrence is well known. He's in South Florida. 6 years, 6 or 7 years.
That was bankruptcy, though.
Bankruptcy court. The bankruptcy courts they'll put you in jail if they give you an order. But there's this Barber case, Wells Fargo v. Barber. This is a situation where she set up a Nevis. It wasn't a trust, but same concept. It was a Nevis LLC. The contents of the Nevis LLC, the assets of the LLC, consisted of a Wells.
She had defaulted on a huge loan, right?
Yeah, it was $61 million.
It's a small loan, and then she funded this Nevis. And didn't she sell her homestead too?
She did a bunch of stuff wrong, and she did things wrong ahead of time as well. And we've got 31 slides, but this is an interesting case.
We've got 31. Do you think we'll get halfway through?
We'll get
I don't know. This was a 2-hour presentation.
Right. Wells Fargo v. Barber.
You see that? 31 slides.
If anybody wants to look at the case, it's not very long, but it essentially stands for the proposition that a court in Florida will, under certain circumstances, especially here where you have what the court views as a bad actor. I don't want to pass judgment, but the court viewed Miss Sabrina Barber as a bad actor. She's moving assets all around, running from Wells Fargo, and Wells Fargo argues in the court, Judge, you've got a Nevis LLC, but the assets are here in Florida, and so you can apply Florida law to foreclose on the single member LLC. Nevis wouldn't allow the foreclosure, but Florida will allow foreclosure on a single member LLC. You can use Florida law, issue a foreclosure order. then Wells Fargo takes ownership of the LLC and the bank account and the assets that are in it.
They called the NonUS LLC a Florida LLC. We were taking bets on this. I didn't think they would do it. They actually made the NonUS LLC into a Florida LLC. I thought they should have just said it's Florida. It's a Florida fraudulent transfer. The assets are here. Let's take the assets. But logic doesn't always work.
They could have done that as well.
Yeah.
But that case is where we come up with what we use a lot to rely on for the strategy for creating the trusts as well. Put the assets and everything somewhere else. Now, if you do have the assets abroad, we look back to 2014 to the Sargent case. This case is still going on. This was profiled in the Wall Street Journal about a year and a half ago. It's an interesting story.
Did he go? Did they go after him?
They've been chasing
abroad?
the guy all over the planet. Sargent is subject to this, or I forget who. I don't even remember now.
Sargent was the plaintiff.
Judgment. Yeah.
Alsala was the debtor.
He was sued, and the judgment creditor asked the court to issue a turnover order, essentially tell him to turn over his stock assets here in Florida, but the stock was located outside of Florida, I think in a couple different jurisdictions.
Dominican and Emirates.
Okay. And I think, wasn't there some in Ohio or something? Anyway, he had stock certificates. So we learned a couple of things in this case. One, the court in that case said the assets are somewhere else. Your remedy is to go to those jurisdictions with your judgment, domesticate your judgment in that particular jurisdiction, and pursue the assets there. So it's an advantage, and it's why we say make sure the assets are where you want to essentially stand your ground for any type of challenge. Another learning point from Sargent is that, and we know this isn't an LLC topic, but it's a broad asset protection topic. There's an advantage to be found here in creating certificates, because even though the LLC interest, or the corporate interest in this case, is by some would be considered to be an intangible interest, it's a right in the company. When you certificate the interest, there is an argument that wherever the certificates are located is where the creditor needs to pursue them. So here, because the certificates were located outside of Florida, the creditor had to chase after the certificates in that jurisdiction. In Barber, the difference there and how it's distinguished from Sargent is that the court in that case, apparently the interest was not certificated, and the court found that the interest was an intangible interest in the LLC, and wherever Miss Barber was located is where the company was. And the interest was. And so since Ms. Barber was sitting in the courtroom or subject to the court's jurisdiction, so was the LLC interest. So then that raises the question that we don't have an answer for, we can only guess, but what would the court have done, or what would the argument be if you had Ms. Barber with actual membership certificates that she had put in NonUS, and then make the argument the certificates are in NonUS, you need to go to find the manager and the certificates in NonUS and go after them there.
Well, we know what they would have done. They would have said it was a fraudulent transfer. She left the assets in Florida. They would have grabbed the assets in Florida.
Maybe.
Right?
I don't know. I would have given you an argument. So I always recommend you use certificates. Brian, if you see anybody check, Brian's on mute here.
Brian's on mute.
We're going to start the tax stuff here. So, oh yeah, I'm using the pen.
Why is Brian on mute?
There you go. I don't know. All right. So now we're going to talk a little bit of, this is on the foreign trust. Here's a little chart.
Some attributes. It's attributes.
Attributes.
It's different.
I'll let Gary
well,
each
country, it's a little dated, but each country that offers the foreign trust, when you choose which foreign trust you want, you go for the attributes.
Okay. What about the nicest beach?
Huh?
The nicest beach?
Well, the reality is on the foreign trust is that the major attribute is last night I was doing a seminar in Polk County, and I asked, well, who's got an idea of what a foreign trust is? Someone says it's foreign. And the reality is that the key to it is that it's foreign. So when you have a domestic judgment, the judge has no authority over the foreign jurisdiction, and you have no full faith and credit in the foreign jurisdiction for them to really abide by the judgment. There's comedy, so you sometimes record the judgment there, but there's no way to reach the assets. It's very, very difficult. That's really the major advantage. The rest of it has to do with, well, if you funded the trust, how long before the fraudulent transfer statute of limitations goes away? Are there barriers to bringing suit like bond or using a local lawyer, no contingency, this kind of thing? So in reality, they all work pretty well.
All of them work pretty well, but let's see if this works here. Watch this. All right, see this? Look at this here. You're digging that, aren't you? Oh, I don't move that. Hold on.
You just
right
moved
here.
it. That was
No.
cool.
See, NEVIS
NEVIS. Look, it has all the check
has
marks.
all the check marks.
Yeah.
So when we talk about using NEVIS, that's why NEVIS is very popular, becoming very popular, at least in our office.
The greatest
Brian
LLC.
and Gary
too.
will look at NEVIS for the LLC and for the trust. Things like a bond being required, and you can't hire a lawyer on a contingent fee to pursue a
it's very hard to get. It's very hard
judgment
to
against NEVIS
enforce
asset.
it.
Right.
Yep.
Okay.
Yeah, asset protection.
Who wants to talk about a little bit of selecting trustees and protectors?
We always recommend corporate trustees. And then a lot of times people are not as comfortable with even domestic asset protection trusts. Even domestic and international trusts allow for protectors. So it's not a trustee, it's someone, you can create the role, actually, you can create the powers, but typically the protector has a veto on distribution. So if you're worried about the trustee running off with your cash, you create a protector, and the trustee cannot make any distributions without permission of the protector. And we always recommend that. We recommend the corporate trustee and maybe a protector who's a trusted friend or family member. And I'll work through these things here. Basically, we're going to go through some of the taxes, effect, and compliance there. That when you start the foreign trust as opposed to the domestic trust, the tax compliance is substantial. It is a totally different undertaking. You've got your 3520, you've got your foreign accounts and your foreign asset disclosures. It's a totally different tax package. You've got, will the trustee manage investments? Usually not. Usually it's the grantor will have the right to pick the investment agent, or it will basically be left to the grantor, because the trustee is really interested in just collecting trustee fees. Unless it's a domestic bank, the domestic banks often will act as trustee and and manage the money as well. It's not usually the same division, but offshore trustees are corporate, and we would use an offshore, completely different financial manager typically.
A note about using, if you're doing this onshore and you're going to another jurisdiction to do a self-settled trust, you can't just say, okay, the trust is in Nevada, so I'm going to go open up a bank account in Nevada. Because if you go to, let's just say Wells Fargo in Nevada, if it's not separately chartered for Nevada, then chances are I can still get to those assets here in Florida. And we do that a lot, where somebody has an account they may have started somewhere else in another state. But if I can go to a branch in Florida and garnish or attach that account, and it's connected to the Nevada account, then there's no protection. So you have to pick a financial institution that is separately chartered, ideally in the jurisdiction where you're going to, if you have cash or other financial
solely
assets.
chartered there.
Solely chartered there. So we're seeing that a lot in Nevada and Delaware. We're seeing large institutions names that you would know, that actually have a separate bank or financial institution that are just chartered in Delaware or in Nevada.
All right,
tax considerations. Sounds like Brian.
The fun stuff now.
Oh, yeah, both.
Yeah, so from the perspective of taxation, if you use a foreign entity, you need to be aware that the taxation of the entity itself, it changes everything from the perspective of how the entity itself, is it a granted trust or not? From the perspective of the creation and the powers that are involved inside the trust, but also the actual funding of the trust, depending on how it's structured. Generally, when you use an asset protection trust, you don't use a completed gift, and there's a reason for that tax wise, which is under 684. But mainly, The idea being is that from the perspective of income taxation, nothing changes. But at the actual distribution scheme will affect, if it's a foreign trust, you know, how you structure it, and then also the compliance behind it. But basically, if you're a U.S. person, all your worldwide income is subject to income taxation yearly on an annual basis. Likewise, if you're a U.S. domiciliary citizen, a long-term permanent resident with a green card, all your worldwide assets are exposed to the U.S. estate tax on death. So basically, if you're here, everything is pulled into the net. That's the main thing. Next slide. Now, if you're non-U.S., so if you're a non-resident, non-citizen, or if you're a foreign entity that might have assets in the United States, those rules are different. From the perspective of a non-U.S. person, the main exemption for U.S. assets are intangibles. So if you have U.S. stock and you're a non-resident, non-citizen, and you sell it, you don't pay U.S. income tax. It's exempt.
No capital gains. No capital gains for intangibles.
Right. No capital gains. So it's a big loophole inside the tax code. Obviously, when you have non-U.S. individuals, treaties apply. So you might have some, so you eliminate double taxation. You need to be aware of that. There's, for the different types of passive income, there's a 30% withholding on that. And then you have graduated rates for effectively connected income as relates to businesses that are conducted in the United States. Now with foreign trust, the way it works is if it is classified as a foreign trust, the income itself, unless it's, sorry, I'm being distracted.
Unless it's US-based, yeah.
If the, as for the taxation itself, so the foreign trust, the income, if it's U.S. source, the federal entity, the foreign entity will pay the tax, but the U.S. bennies will not receive tax, will not be taxed unless it's distributed out in that year. Otherwise, the entity is not taxed. And if it's a foreign asset or foreign income, there's no U.S. nexus, so the taxation does not apply. So if you are a non-resident, non-citizen, and you create a foreign trust, that income that's inside that foreign trust is not touched by the U.S. tax code, income tax-wise. So there are a lot of things you can plan, especially if you pre-immigration planning.
Foreign assets.
Foreign assets, yeah.
Yeah.
Offshore.
And then, just as a backdrop, it's not part of this seminar, but there's no reason that a foreigner would ever pay any U.S. really income tax on a lot of different things, and an estate tax can be completely avoided through the use of a foreign entity to hold the assets. But on the income tax side, it's just the U.S. source.
Yes, that's correct. Next slide. The estate tax is a little different. The estate tax is based on domicile, and the idea being that if you're a U.S. citizen or a long-term permanent resident, and you physically reside in the United States and you intend to remain, your worldwide assets are subject to the estate tax. That does offer potential for certain types of planning. If you're a long-term resident, so it's possible that you might be able to switch your domicile, but the main thing is that the tax test to determine if you're an income tax, U.S. income tax resident versus estate tax or transfer taxes, the tests are different. And so you might be one for income and not for estate, or vice versa. So you need to be aware of that. And so that's one of the things that's important that you might not know. And obviously the gift of intangibles is an exception. If you're a non-resident, you're able to make gifts or transfers of U.S. intangible assets and not have to face the U.S. transfer tax.
What if you die with them? What if you die with the same intangible?
Well, that's an interesting question. If you die with it, it's a U.S. situs asset. So if it's owned individually, it would be pulled into the U.S. estate tax, and you would only have a $60,000 credit. That's it.
Right. So you have to give away these intangibles. But what I was mentioning was on the estate tax, if you're foreign and you're not a resident, you really shouldn't incur estate tax because we can use this foreign entity to hold all your U.S. assets.
Right. And you should never own U.S. real estate individually if you're a non-resident, non-citizen.
Never.
Never. Next slide. Okay, now, what is a foreign trust? Well, the tax code tells us there are two tests. There's the court test and the control test. If for a trust to be considered a domestic trust, which is so a U.S. income tax entity, it has to be able, a U.S. court has to be able to bind trust operations. So where the situs of administration is would be within the United States. And then also on the other prong of the test is the control test. So where's the trustee? Are they in the United States? If you have both, you're a domestic trust for U.S. income taxes. If you fail either or both, you're a foreign trust. That's the rule. Next slide. Now, why is this important? Well, if you're a U.S. resident and you create a foreign trust, so you want an asset protection trust offshore, which is the most common, you would create it and add creation, and you would transfer assets into it. Well, with some exceptions, the transfer itself of assets from a U.S. resident to a foreign trust, unless an exception applies, is an income taxable event. It's a deemed sale under section 684 of the code. Regardless if the gift is completed or not, that's a state tax, that's its own test. But for income taxes, if you create a foreign trust and you're a U.S. resident and you have, so let's say that you actually do that, generally when we create that, the person who creates it is a beneficiary, or their family is, or a U.S. resident is. So it would, the exception to that is under 679, it basically puts a pause on that and says there's no deemed sale until either the grantor dies, because it's a grantor trust, tax-wise, or there are no longer any U.S. beneficiaries. That's when 684 would apply. So when you have these things, it's important because you might have a domestic trust, maybe one in Florida. Well, if somebody dies or resigns, and first you have a trustee that's in Florida, if an aunt or uncle in France becomes the trustee, guess what? When they accept as successor, you no longer have a domestic trust anymore. You have a foreign trustee.
And if
when
you
that occurs,
don't have the U.S. beneficiaries, right? You could have a deemed sale of all those assets.
Right.
For income tax purposes, not estate tax, for income tax purposes.
So there are two different tests, and there's two different analyses that you have to go through to make sure that you don't run afoul of the income tax rules. Because even though from the perspective of the estate tax, you have a $11.58 million exemption amount. So you might make a transfer and think, oh, I'm home free, I don't have to pay any tax. Well, that's true on the estate side, but not on the income tax side. And the reason why is if you give assets to a foreign trust, it's basically an expatriation of the asset outside the tax net. That's why they do that. That's the concept behind it. So the exception to that, though, is if you have the person, the U.S. owner creates one, if they're a beneficiary of their trust, then 679 says it's just a grantor trust, nothing happens until death. And generally, when we would create one of these for an asset protection trust, it would be includable in their taxable estate, the person who created it. So when they died, if it's includable in your taxable estate under current law, that you get a step up in tax basis for fair market value at the date of death. So when 684 applies, there would be no gain, taxable gain at that time.
So it's harder to make it into a gift tax type estate tax strategy, because if we complete the gift, and Brian can chime in, we write on this all the time. If we complete the gift to the foreign trust, we actually get it out of the estate, right? We still have the U.S. beneficiary, so that on the income tax side, there's no deemed sale, but on the gift tax side, it's out of the estate. Well, upon death, you're going to have that deemed sale, and you're not going to get the step up in basis.
And that's with appreciation as well. So the assets might have gone up in value, from when you first made the transfer. So it can be a trap for the unwary, for sure. But you know, when we create these, they're usually used for asset protection reasons. And so we would recommend normally that it would be an incomplete gift, so that upon death, if it still exists, those assets are pulled into the gross estate, and there's no 684 tax issue at death because it's already in the estate, and then you have a step up in basis.
And now if you really run into a problem where it's a very wealthy person and they had gotten those assets out of the estate, we could redomesticate that trust.
Right. And so if you redomesticate it, then at death, there's not a foreign trust anymore. So 684 would not apply to that at the person's death when there's no longer a U.S. Benny or the grantor dies. It's the earlier of. That's how the test works under 684. Now, from the perspective of a foreign trust without a U.S. owner, it's basically for income taxes, it's treated as like a non-resident alien with some modification. So if they have foreign non-U.S. income, it's not taxable in the United States because there's no nexus. That's basically the general rule. And then if it's distributed out to the U.S. Benny, they would potentially push that income out to the U.S. Benny when they receive it on a K-1.
And you have to be very careful if the grantor or a big Benny is part of one of these foreign trusts and comes into the States.
Right.
Because now you're going to have a U.S. person with a foreign trust, and it may fall within this net of deemed sale.
Right. Especially if you have a foreign individual that creates one of these, and they decide to immigrate to the United States within 5 years of creation, and they have U.S. beneficiaries as part of the foreign trust, you're going to have a 684 event. At least it's pulled in. Now it will be postponed as long as there's a U.S. beneficiary and the U.S. grantor deemed when you come in, you're deemed to have made the transfer on that date within that 5 years.
Upon death, you got problems.
Right. Absolutely.
I bet everybody's dreaming of happy hour now.
Exactly. Tax stuff's great. Next slide, please. So I'm going to go through this briefly. Basically, if you have an individual that wants to come into the United States, they want to immigrate here, and they're very wealthy. The idea being that they have foreign assets, so there's no U.S. situs. The idea is you want to get rid of those out of their estate before they come in, because once they come in and they get their green card and they're domiciled here, it pulls it all in, and it's then exposed to the worldwide assets. So there are ways to plan besides, the easiest one is just direct gifts to non-U.S. individuals. But if they wanted to have a foreign trust, they can do that, but they have to wait 5 years before they immigrate to the United States. That's the basic rule. Otherwise, you have a deemed sale when they come in within that 5 years under 684.
It's 5 years from funding.
From funding the trust, yes. Now, from the perspective of compliance, these things are great from an asset protection standpoint, but when you use them and you utilize them, there are annual compliance requirements that both the U.S. owner is going to have, the foreign trustee is going to have, and the U.S. beneficiaries are going to have. And for the U.S. beneficiaries, that's true even if they don't receive any income in the taxable year. It's an annual event you have to file with your 1040. The main form is a 3520. That lets the IRS knows that there's a foreign entity, it's a foreign trust, and who the beneficiaries are. That's required annually. And if you don't file it, the penalties are draconian. Now, along with this 3520, the U.S. owner will also have a statement from the Form 3520A, which is done annually by the foreign trustee. It's just an informational statement that they attach so the IRS can trace these funds and where they're coming from. Next slide, please. The 3520A is required by the foreign trustee each year, sort of the same thing. It's, it's a balance sheet of what happens income tax wise. And then on that, you'll also have basically the K-1 statement where they're sending stuff out or not. That's what the IRS used to match the income each year. And the foreign trustee is required to do it. But if they don't for whatever reason, the U.S. owner is responsible. So
It's
you
a
need to make sure
matching,
that
a
that happens
matching,
each year.
everybody.
Yeah, and it's due March the 15th each year, a month before the annual one is due for the individual. And then for the U.S. beneficiaries, the rule's the same. If you're a beneficiary of a foreign trust, you have to file this form each year, even if you don't receive any income from the trust. It's just the way it is. That's the compliance requirement. You will also, if you do receive income from a foreign trust, the beneficiary will receive a statement from the 3520A that you will attach to this form when you file it. Next slide. We talked about the 3528. I think you went back the other way.
It's the pen. It's the electronic pen.
We talked about the US. Okay, so that's the 3520 and the 3520A. Now, there are some other forms. That's not it. There's more because you have foreign assets now. So now you have the FATCA requirements. So if you meet the certain thresholds each year, if you're married or unmarried, if you're in the United States, outside the United States, if your foreign assets exceed these thresholds,
You have to file.
you have to file each year. You have to. And then likewise, you also have your FBARs from FinCEN. That's just $10,000 each year for a foreign account. So these are mandatory things these individuals have to file every single year. So while from the perspective of asset protection, they're great, the compliance requirements for utilizing these instruments is rather large. Next slide. Right. Switch over to Eric now.
All right, I'll take the ping pong ball. We got a few minutes left. So we talk about using cryptocurrencies with asset protection trusts. The reason how this idea came about, I wrote about 5 years ago, probably 4 years ago, when cryptocurrencies were getting hot. I wrote an article that ended up in Forbes, and it was 2 of them back to back. I said, why, if you have this issue that I talked about earlier of having assets that you don't want in the jurisdiction of where you have your asset protection trust or whatever's holding them, and you want to get them out of the jurisdiction, what about something like a cryptocurrency that's really a virtual asset? It exists wherever somebody can access it through the key that allows you to access your cryptocurrency. And so the idea that I had proposed was that you would take your key, your wallet access, which is your long key that allows you to transfer cryptocurrencies, and you could move that, give that access to a trustee or somebody in a different jurisdiction. Understanding cryptocurrencies, the first fundamental issue is understanding how you hold them. They don't exist anywhere. You can't stick them in your pocket. You can stick them in your brain. The 5 main ways are listed here. There may be even more that people have come up with, but basically, cryptocurrencies exist in a world where you have, and I don't know how many people that are with us today have ever played around with these. What I recommend, if you're interested, if you want to learn about this, is just go, Bitcoin's the most common, but you could use Ether. You can go on a place, an exchange like, oh my gosh, what's the exchange is the most popular one is the one that got subpoenaed by the IRS.
Oh, Coinbase?
Coinbase. So Coinbase, you can buy several cryptocurrencies. You link your bank account. You pay a fee. I don't recommend you keep them on Coinbase, but that's an exchange for cryptocurrencies. You can buy a Bitcoin out to 8 decimal points. I mean, you can buy a really small amount for less than $100 and move it around between wallets. And on this paper here is an example down here of what a wallet looks like. You've got a number here and a number here. And if you want to send the Bitcoin somewhere, you basically can hold if you're doing it for like a phone, you can get this QR code, or you can put the numbers in and to show where you want to send the Bitcoin. And then, so that's the public address. And then the private key is what you put in because you're the only one who knows it. And you can send the amount of Bitcoin you want to that particular wallet. And it runs all through an internet, essentially a virtual exchange. You can keep the Bitcoin in either a cold storage or something like think of a thumb drive, something you plug into a computer. Once you disconnect it, it's not connected anywhere to the internet. Cold storage is how we refer to that. You can keep it on the desktop of your computer, but if you lose your computer, you lose access to the Bitcoin. You can keep it in other locations on the World Wide Web in a cloud-based system. you need to have a password or some way you need to understand and have a recall mechanism to access it. People put them on mobile phones. You can keep it on an exchange, but it's not recommended that you keep large amounts on exchanges. Bitcoin has never been hacked, but exchanges have. And then finally, you can just have a piece of paper like this wallet. This is a paper wallet you can print out, and you can put this in a safe deposit box, or you could actually just take these digits again here that are on the wallet, and it's down at the bottom of my screen. And if you memorize those, now you have a brain wallet. That's what I referred to earlier. So that's how you hold Bitcoin. I'm looking at our time here. We've only got like a couple minutes left. What makes Bitcoin and other cryptocurrencies, but in particular Bitcoin, so unique is that there's no intermediary for the transfer of value. Essentially, you can transfer going through an exchange, through a platform. I'm trying to think of a layman's way to explain this in 2 minutes. It's just not going to happen. But there's like a credit card system runs to a Visa exchange. Banks are typically intermediaries for wire transfers. Bitcoin can be done where you transfer from you to another person somewhere else where you may not know who the person is. The person doesn't know who you are. And it's all done just by virtue of having the address that you saw on the wallet. Right down here, this is your public address. You can give somebody this address with no other information. They can go through the blockchain technology, transfer, instruct blockchain by putting in this private key information to send you a certain value in Bitcoin, and poof, within a couple minutes, the exchange on the blockchain takes that information and makes the transfer. That is all done through using cryptography or
that's the blockchain.
Yeah, using the blockchain. I'm not using the right word even right now, just because of the timing, I think. But it's all done essentially through a system of math and codes where the community who's able to access blockchain verifies the transaction and allows the transaction to pass through. Why would anybody do that? People do it because you may generate a fee, or because that's what the miners are doing. If you ever hear of the term miners get paid because if they solve the blockchain, each transaction is solved essentially by a mathematical puzzle. If they solve the puzzle, everybody agrees on a solution, and it transfers Bitcoin. It recognizes a transfer from one sender to one recipient with no other information involved, with a virtual world verifying and validating that transaction with no intermediary. That's essentially what makes blockchain unique in the 2 minutes that I had to explain it to you. The other reason...
in a foreign trust, you have the number. So
so
you kind of came up with this idea is you could split the number, give half to the trustee.
Right. So how does this work? Yeah, if you have a foreign trust, and this is actually, Gary brings up the point, I should just stay on this wallet right here. Think of this wallet that I've circled here and I have on the slide, and you could, for instance, you could tear this in half or white out black out some of the numbers here. Give this to, if you had a foreign trust in Nevis, give part of it to one trustee and give part of it, for instance, to another trustee or to a protector, or keep it for yourself. Nobody on their own can access the Bitcoin, but everybody together can. And if a court then brings you into court and tries to compel you to turning over access to the Bitcoin, all you can give them is whatever digits you have here, and then you still need the foreign trustee. So it kind of lends itself to being the perfect asset to be held in a foreign trust, where you maintain some level of control, but you don't have total control. Of course, the risk is you have to get both sides to agree in order to transfer the asset. But if anybody's interested in that, you want to hear more, I see we're at our time. I don't want to go over. I do want to allow if there's a couple questions. I can forward you the little the pieces that I did for Forbes talking about it. And I think if you go to YouTube, we have a YouTube channel where we spend an hour talking about just the cryptocurrencies with asset protection, and then we've done another one with cryptocurrencies with tax.